So, with that having been said, I have been doing this, as I have said now, since the beginning of time on this podcast, which has been 6 months. That I've been practicing law for 42 years, and good, bad, or ugly, I have seen a lot of stuff. And the first thing I want to kind of walk through is the top 5 mistakes I see defendants making after they've been charged, and I literally see them every week. The first is not showing up for court on time. How you can be a defendant in a criminal case and not think that getting to court on time is important is beyond me. Because guess what? The prosecutor got there on time, the judge got there on time, I got there on time, and the very last thing you want to do is show up and say, couldn't find a place to park, there was a bad traffic, there was a wreck. It's like, come on, dude. They're trying to put you in jail. The least you can do is show up here. Second thing is dressing inappropriately. And my God, it's like some of these humans live in a mirror-free zone. Most of my clients are better about this than a lot of clients I see, but some of them look like they came from P. Diddy's after party. It's like, what are you wearing that shit in a courtroom for? They look like the pledge that cleaned up all night after the frat party. It's just like, what? See, we want to separate ourselves from everyone else in the room. We don't want to be cast in the same net. We want to be different, look different, and get treated different than everybody else in your pledge class, Hoss. So don't dress like you just left P. Diddy's after party. Third, not following conditions of bond. Here's the reality. These aren't options. These are mandatory conditions. And when, for example, if it says that you shall not have any contact with the complaining witness in your case, don't have any contact with the complaining witness in your case. Well, she called me. It says no contact. It doesn't say if she started it. It says no contact. Because what can the judge do? Oh, yeah, put you in a cage until we're ready to try your case. The fourth, and this is a little personal to me and any lawyer, is slow paying or not paying their lawyer. Whether a defense lawyer wants to admit it or not, they like to get paid. And part of their incentive in working hard for you is, oh yeah, getting paid. And when you slow pay them, although ethically, appropriately, in a perfect world, maybe it shouldn't affect them, it does. So don't slow pay your lawyer. And the fifth and final one, at least for this, is these clients that want to Google or artificial intelligence their defense. They'll put it in Claude, they'll put it in AI, and they'll tell their lawyer who's gone to law school, not Google school, or AI's actual law school, passed the bar, practicing law, and they'll tell him, well, here are the issues in the case, and here's how you see it more and more and more, and they will just send you these multiple page Google AI-driven stuff that has sick 'em from come here to do with their case. So those are the easy ones I see.
Dan, I mean, this is a great list. There's so much simplicity almost here that I don't think people, understand and realize. I know you're not like ranking these like the number one thing. It's kind of more bullet points, but is there one of these that happened more? Is not showing up the thing that genuinely happens more
I think
often?
the thing that I see, look, 4 and 5 are kind of personal to the lawyers, right? The thing I see that causes the most havoc, Aaron, in my client's life is not following the conditions of bond, and then having the judge revoke their bond, and then having them sit in jail for the simple, reason that they couldn't follow conditions of bond. And there's a titanic difference between preparing for trial with your client in your office, getting ready for trial or getting ready to resolve the case, and trying to explain the nuances of a defense or what's going to happen in trial while he's sitting in a cage. I mean, you literally don't even have any physical contact in state court, in the state jail. In the federal system, you can go see your client, but it's an awful burden on the client. It's an awful burden on the lawyer when all they had to do was follow the conditions of bond. And it's not hard, but when they screw it up, which is quite frequent these days, they screw it up and they get their bond revoked.
And when you say not following the conditions of the bond, what does that mean? And like, is there a common one that like causes them to not follow?
And to follow up on that too, is it like uniform across?
No,
each
it varies
case?
from case to case.
Okay.
So the most common one I see, Tommy, is failing to avoid having contact with the complaining witness, right? And it might be their wife, it might be their boyfriend, it might be, the victim or whatever. And they'll reach out to that person, or that person will reach out to them and begin some conversation, however benign, and the judge will be informed of it. And all the judge has to do is find by a preponderance of the evidence that the violation occurred. There you go. Your bond is revoked. You can't appeal that. You can't take it to the Court of Criminal Appeals or the Supreme Court or the Fifth Circuit. You're going to sit there because your dumb ass couldn't follow something that was given to you in black and white. A lot of defendants, nobody will ever find out, or it's not that big a deal. And if the judge finds out, she'll be mad at my ex-wife for. No, she won't. No, he won't. They're going to be mad at you. You're the person who's on bond, not the other individual. But that's the one you see the most.
So if they're getting called by their partner and they answer the call, that's on them. They should just ignore the person altogether. Yeah, I mean, the whole slow paying or not paying, I think is kind of a general consensus across all professions. I don't know any professional that appreciates getting slow paid or not paid for their work. I think, more often than not, if you grease somebody up front or give them the money, they generally work harder. Is that something that you feel like translates into the field of law? Like if your client pays you and pays you well in the beginning, that you're incentivized to work really hard for them? Do those things?
Aaron, if every client I ever had paid all 100% of their fees, I wouldn't be sitting here having this conversation with you. I'd be retired in Los Cabos, right? It's just a sad reality of the practice of criminal defense. But more importantly, most criminal defense lawyers, not all, but most criminal defense lawyers will set a flat fee, right? Because a couple of reasons. Number one, the client wants to know how much it's going to cost, as opposed to the big civil firms who charge $600 an hour or $800 an hour or $1,000 an hour or whatever. The difference in criminal cases versus civil cases in that tiny regard is this. It's not a tiny difference, it's a big difference. In civil cases, if your client quits paying you, you can file a motion to withdraw, and the judges almost always will let you withdraw. They don't extend that same courtesy in criminal courts. It's called a Green motion. Mr. Green didn't show up, so I want to get off the case. Years ago, judges would fairly commonly or fairly frequently allow you to withdraw. They won't do that anymore. And in federal court, you're never going to get a federal judge, rarely if ever, will grant a motion to withdraw because your client hasn't paid you, right? So, in deference to the client's desires and in trying to figure out what a fair fee is, a lawyer will set a flat fee. Let's say it's a $20,000 fee in an aggravated assault, okay? Well, guess what? If your lawyer has to go fight a motion to revoke your bond, he's spending part of that money, for lack of a better description, fighting your motion, your motion, your bond revocation motion, meaning you're really forcing your lawyer to spend the time that he has mentally set aside to defend you on screwing around based upon your failure to follow bond conditions. It's a real problem, right? So if your bond is revoked, you're going to have to set it for a hearing. You're going to have to call witnesses. You're going to have to cross-examine their witnesses. And those are 6 or 8 or 10 hours that you had mentally allotted to defend your client's criminal accusation that you're spending on corollary bullshit that could have been completely avoided. So, that having been said, if a client pays me up front, I'm probably going to return his text quicker than a client who doesn't pay me. It's just human nature, and I think any lawyer in town will tell you the same thing.
100% human nature, and I'm in different industries that have the same kind of school of thought. Kind of last thing on this slide, unless Tommy you have something to follow this up with, but the whole Google their defense and AI their defense. I know we work with a pretty badass trauma surgeon. He's a lawyer. He's a doctor, and he always would complain about the people WebMDing their problems because it was always like over dramatic. And this is back in the day before the AI tools and LLMs have really picked up. But now it must be even more frustrating because I get agitated getting, in-mails and DMs that are AI, written, because it's just so obvious and it's just lazy almost. There's studies now that are going out that people's brain receptors aren't like firing off as much because they're just letting AI kind of think for them, right? So can you kind of explain a little further what that experience is like when they're bringing all this AI information and how you handle like, either debunking or just rebuttaling or whatever?
Well, every criminal case, just like every surgery in your physician's case, is different, right? It matters what the charge is, who the judge is, who the prosecutor is, what your relationship is, what your skill set is, how much money the defendant can pay you, and how you're going to devote the fees to specific parts of your case. And AI is a wonderful tool, right? But it doesn't take into consideration any of that. Who the judge is, who the prosecutor is, what the history of the court is, what the predisposition of the prosecutor is, what's your relationship with the judge, with the prosecutor. It's a decent starting point, but for a client to think that they can AI their way through a defense is insane, because I did hear that AI passed the bar, that some AI actually passed the bar. That's different than trying a case before 12 people, right? It's vastly different.
So like if they're organizing their thoughts through the tool so that it's a little bit more polished of an understanding of what they're going through, does that help you in that circumstance?
Of course. And I'm happy to have a dialogue with them about anywhere they want to go within reason. But when I get a 12-page single-spaced outline of where they think, how they think I should defend the case, and I know that they went to Texas State University and flunked out after 18 months. It's probably not written by them.
The good ones come from A&M, I've heard.
There's a couple more on that slide that I want to talk about that I feel like are interesting, but may not just be related to just defendants. So like the first one, not showing up on time. Have you had any lawyers?
I've actually represented at least 4 or 5 lawyers and a couple of judges who showed up late to court. It's like, what game are you watching, Your Honor? It's like, this isn't hard. Yeah. You would have revoked that person's bond, and here you are showing up late. Well, I got stuck in traffic. Come on, Judge. When's the last time you said, oh, don't worry about it, when you were on the bench? I mean, what are you thinking? Yeah. But here's the problem. And it's not just endemic of my client base at all. It's endemic of the free world right now. Everyone's special. Everybody thinks they should get treated better than the next guy. Everybody wants the easy pass. Everybody wants the toll tag. Nobody wants to stand in lane and stand in the queue like everybody else. So it just trickles down. And as frustrating as it is for me, they suffer the consequences of it. It gives me heartburn for 15 minutes, but guess what? I'm coming back to my office every single time. You may not be. So you got to play by the rules, Hoss, every time.
And I feel like that answer also is the answer for the second point, which is dressing inappropriately, because as long as I'm a good lawyer, why do I have to, dress a certain way? So,
this is called a profession, right? Not a nightclub. You should dress like you're a member of a profession, not that you're going to get drinks after work, right? Yeah. And again, this isn't just affecting the legal career. Everybody's got casual Friday. Everybody wants to work from home. Everybody wants to sloppy it up. Yeah. But when you are fixing to run the gauntlet of a criminal case, you want to separate yourself from everyone else. You want to be better, look better, present better than everybody else in that courtroom. That's your goal. And when you roll into court with suit slacks that doesn't match your sport coat and unshined shoes and a shirt that hadn't seen the dry cleaner since Nixon was in office, it's a real problem. People are going to take you less seriously. They just are. You don't have to show up looking like you just left the runway or the catwalk in France, but show up like it matters, because it fucking matters.